2026-11, a resolution authorizing the village council to direct McNamee and McNamee Law Group to produce all unredacted legal billing statements dated from January 1, 2024, and acting municipal manager and finance officer to provide payment and expenditure documentation for council review, including enforcement and administrative actions for non-compliance of all past and future legal billing invoices. I'm sure that the law director would like to talk about that, so sir, you're up.
Yes, well, I was asked about this particular resolution, but Your Honor, before I start there, I want to revisit Councilman Joy's comments under unfinished business. You're correct, it was not unfinished business. So I suggest that moving forward, unfinished business is to deal with legislation that has not been reviewed and passed. So that's what the purpose of that is for. So moving forward, I think Councilman should be found to be out of order. But in that same vein, he did mention conduct, my conduct specifically to Mr. Stafford. And Mr. Stafford was here, and we had a discussion that did not comport with my standards of professionalism. And I tendered an apology to Mr. Stafford at the city of Fairborn last night for similar conduct. And I'm going to be consistent and tender that same apology to him right now. So Mr. Stafford, I hope you accept my apology. So with that out of the way, I want to address the resolution, Mayor, that you just read and that were put on the agenda by Councilman Joy. And I've dealt with Councilman Joy on this particular issue for 2 long years now, and it's grown a little weary, so I hope we can dispense with that today. So I've got a PowerPoint presentation prepared, I've got a legal opinion prepared, and we're going to painstakingly go through that. And I hope it's not too painstaking, but Christina, if you would start with the video.
It's coming through on the projector. The volume. Is that what you guys use?
I have no idea.
For the volume?
You want to use the mic? Just carry the mic over.
Yeah, get the mic to it.
Enter the mic. File, if you will, please.
Turn it on.
You're gonna start from the beginning too.
Yep.
Councilmember Joy, what is the problem that's going on with the council refusing to honor your public records request? Because it's very clear, the Ohio Sunshine Laws are written in stone about providing information. So,
Jason,
for Joy,
Do you want me to give you a different one?
there's 2 buttons to push, there's on and then there's.
Yeah, it says it's on, but there's no lights on it. One slide.
Councilmember Joy, what is the problem that's going on with the council refusing to honor your public records request? Because it's very clear the Ohio Sunshine Laws are written in stone about providing information.
So, as part of council, as a council member, local government, as part of local government, what we were required to do is provide financial oversight. And what Mr. McNamee is doing is not providing us an opportunity to provide that financial oversight.
Why do you think he's doing that?
I think that there's something on the invoices that he does not want us to know.
Well, that's troubling because we're getting the same information out of Inglewood, but also out of Fairborn, where he is the law director. It seems to be a pattern of behavior that needs to be addressed. What's your opinion?
It absolutely needs to be addressed. It needs to be addressed by the Ohio Ethics Commission and the Attorney General.
Thank you very much.
Okay, so then Christina, if you would go to the next slide. think there's, yes, okay. So, the purpose of this presentation to explain what is being requested, to clarify what the law requires, to identify risks to the village, and to provide recommendations going forward. And Mayor, you kind of brought this up. Now, when I get stopped on the street by somebody, what's the big deal about the invoices? So, let's get something clear. I'm not hiding anything. What I'm doing is preserving what the Ohio Supreme Court and my Code of Professional Responsibility requires of me, and that is to preserve the attorney-client privilege. The Supreme Court has held continuously that the narrative portion of an attorney's bill is confidential attorney-client privilege. And so, I don't own that privilege. I'm not able to waive that privilege. It's the village as a entity, not as individual council members, that can waive that privilege. And that's really what this resolution is all about. But let's go back to the video, okay? What Councilman Joy has requested for 2 years now is access to that attorney-client privilege information, the narratives, through the Public Records Act. And the Public Records Act has made it crystal clear, and the Ohio Supreme Court, that an attorney narrative in an invoice is not a public record and may not be disclosed. Period. End of conversation. And with Councilman Joyce filed 2 complaints with Ohio Disciplinary Council against me. Both went down. A complaint with the Ohio Ethics Commission went down. And then he filed suit against the village in the Court of Claims and lost that as well. All on this very same issue, which I've just explained to you in 20 seconds. So now what the resolution is doing, and this is a way to go about doing it, if the village wants to waive that attorney-client privilege, is to waive that privilege as an entity. And we'll talk about the ramifications of that later. Let's see. Council, will pass down the legal opinion I did on this. There's 5. Christina, if you would make, I think we've got some copies available for the public, if you'd like to make those available.
Can you pull your microphone closer, please, sir?
Oh, yes, ma'am. Testing, how's that?
Much better.
Thank you.
Everybody got a copy? Michelle, would you like a job with the village?
What's the pain?
We keep you working until the Legion starts up.
Thank you.
I got plenty of jobs.
Yes, ma'am.
Okay, and, council members, this was just put on the agenda Friday, and so I had spent yesterday and part of today to pull this together. But it's something we keep revisiting, so if you don't care, we won't take the time to go through this. Introduction. At the request of village administration, this opinion addresses whether the village is required or permitted to disclose unredacted legal billing invoices, including narrative descriptions of legal services, and the legal implications of proposed resolution directing such disclosure. Now, just quick a sidebar here. In a legal memo, there's a lot of citation to authority. So for example, if you look at the first paragraph, you'll see C State Ex Rel. Petronville v. City of Avalon Lake, 146, Ohio State 3rd, 292, 2016. I'm not going to read all of that gobbledygook, but just for the public's information. So that's a case that's decided by the Ohio Supreme Court. You can find it in volume 146, third, whatever the 3D stands for, on page 292. And it was decided in 2016. And that's indicating that these are cases with the similar issues that I'm discussing right here. So, all right, applicable law. Ohio courts have consistently held that narrative descriptions contained within attorney billing invoices are protected by the attorney-client privilege and are exempt from disclosure under the Ohio Public Records Act 149.43. The Ohio Supreme Court has recognized that narrative portions of billing invoices constitute confidential communications between attorneys and clients as they pertain to legal advice or services rendered. See the citations to authority. That's what I said to start this discussion. While general billing information such as total amounts, dates of service, hours billed is considered non-privileged and subject to disclosure, descriptions of legal work that reveal the nature of the services performed, legal advice or strategy constitute confidential communications between an attorney and the client and are therefore protected. In cases involving pending litigation, such as we have here, even itemized dates, hours, and rates may be exempt from disclosure where they inextricably entwine with privileged narratives. So, Mayor, in terms of, are we hiding anything? Every invoice, every increment of time billed, every hourly rate of time billed has been disclosed, filleted, parlayed, and marmalade. It's out there, been provided on all public records requests. Additionally, it is well established that the attorney-client privilege belongs to the client. That's what I was saying earlier, which in this context is the village as a municipal entity. The privilege does not belong to individual members of council, and individual officials do not possess an independent right to access or waive privileged communication. See citations to authority. A council member, even as part of the governing body, does not individually hold the privilege and cannot unilaterally override it, as the client is the municipal entity itself and not its individuals. Courts have further recognized that the privilege may be asserted even against constituents of the entity, including members of a governing body, particularly where disclosure would be inconsistent with the interest of the entity, or where the individual seeking access acting in a manner adverse to the entity. This precise issue has already been litigated and decided against Councilman Joy. In Joy v. Village of New Lebanon, 2025, Ohio, 4337, 2025, the Ohio Court of Claims upheld the village's redaction of narrative descriptions in the same legal invoice that it issued here, ruling that the attorney-client privilege belongs to the village as the organizational client and applies against Mr. Joy as an individual constituent, notwithstanding his status as a council member. The court expressly rejected Mr. Joy's argument that his council membership entitled him to the privileged information, holding that the Public Records Act is not the proper mechanism for attaining the attorney-client privilege materials, and that the legislature has determined such materials are not public records. Costs were assessed against Mr. Joy. The proposed resolution is an attempt to accomplish through legislative action what Mr. Joy could not accomplish through litigation, and that's fine, that's his right. Importantly, while a municipal charter may define internal governance and reporting relationships, it does not alter, we're switching gears to another subcomponent of this whole issue here, so I'm gonna start over. Importantly, while a municipal charter may define internal governance and reporting relationships, it does not alter the fundamental principle that the attorney-client privilege belongs to the municipal entity as a whole. Councilmember Joy has pointed to Charter Section 4.02, which requires the manager to report to council on financial and administrative affairs, and Charter Section 4.07, which provides that the law director is appointed by council and is not a subordinate of the administrative services. These provisions define lines of accountability on appointment authority, but they do not confer on individual council members or on council collectively the unilateral right to compel disclosure of the attorney-client privilege communications. The attorney-client privilege is a substantial legal protection, not an internal governance rule. It is not abrogated by charter provisions that address reporting duties or appointment authority. The Law Director's Accountability Council for Administrative Governance Matters does not transform privileged legal communications into ordinary financial records subject to council's general oversight powers. The authority to act on behalf of the client must be exercised in a manner consistent with the entity's legal interest. No provision of the New Lebanon Charter authorizes individual members of the government body or council as a whole to compel categorical disclosure of privileged communications, or doing so would be inconsistent with the legal interest of the entity or would result in the waiver of privilege. Okay, so that kind of sets the table of what we're talking about. Now the analysis. Distinction between public records and internal governance. The proposed resolution attempts to distinguish between public records law and a council's internal governance authority. That distinction is accurate, but does not alter the outcome. While the Ohio Public Records Act governs what must be disclosed to the public, the attorney-client privilege independently governs whether confidential legal communications may be disclosed at all, regardless of the mechanism by which disclosure is sought. This privilege applies whether the request is made under the Public Records Act by a member of the public, through the Internal Governance Act by a council member, or by resolution of the full legislative body. Joy v. Village New Lebanon was decided on public records grounds because that was the legal vehicle Mr. Joy chose. But the Court of Claims ruling that the privilege protects narrative description was not procedurally contingent. The underlying substantive conclusion that the privilege belongs to the village as the organizational client applies with equal force to an internal demand for the same materials. The mechanism of the request does not change the nature of the privilege or the identity of the client. Accordingly, the fact that council is exercising a governance function does not eliminate or override the attorney-client privilege. Rather, any exercise of council authority must remain consistent with the village's legal interest as the client, including the preservation of privileged communications. Now let's go to the argument, fiscal oversight. The village has complied with applicable law by producing legal invoices with all non-privileged financial information while redacting narrative descriptions that are protected by the attorney-client privilege. This approach satisfies both public transparency requirements and the village's obligation to preserve confidential legal information. The proposed resolution seeks production of unredacted invoices on the basis of fiscal oversight. However, the following considerations are relevant. Sufficiency of existing disclosures. As I stated previously, the village has already provided all financial information necessary for oversight, including total amounts billed and paid, as well as time entries. This satisfies the transparency requirements under Ohio law. Importantly, the village's legal services are primarily provided under a flat fee agreement. As a result, the total cost of the village is not dependent on the content or the detail of the narrative descriptions. Courts have recognized that privilege applies even when legal services are billed on a flat fee basis, as privilege protects the substance of legal advice, not the billing structure. Accordingly, disclosure of privileged narratives does not materially advance fiscal oversight. Moreover, the resolution's premise that narrative descriptions are necessary for fiscal oversight conflates financial accountability with access to legal strategy. Ohio law permits disclosure of financial data while protecting privileged communication. The village has already provided sufficient documentation to evaluate expenditure without comprising the confidentiality of legal advice. To the extent the resolution seeks records beyond the narrative descriptions, including payment records, fiscal certifications required under revised code 5705.41, contract or engagement documents, and internal approval materials. Those categories should be evaluated on their own terms. Non-privileged financial records, including certifications, appropriations, payment authorizations, and contract documents, are not categorically withheld by my office. To the extent any such records have been or being withheld, that withholding is limited to those portions that constitute privileged attorney-client communications. The resolution, however, makes no such distinction. It demands categorical production of unredacted billing materials and treats the privilege as a blanket obstruction rather than the targeted protection. That framing is legally unsupportable. Revised Code 5705.41 governs the certification of expenditures against appropriations and does not create an independent right to compel disclosures of privileged communications. Compliance with fiscal certification requirements does not require and does not justify waiver of the attorney-client privilege. Continuing the analysis, the attorney-client privilege may be waived by the client. However, such waiver must be considered carefully. Under Ohio Evidence Rule 502A, intentional disclosure of privileged communications may extend to undisclosed communications on the same subject matter when fairness requires consideration together. Additionally, voluntarily disclosures to third parties generally destroys the privilege entirely. I'm going to take a sidebar here and explain why this is important. The prior regime, what I'll call the Glenn and Madden regime, has basically been replaced. There's only one remaining council member from that regime, and that is Councilman Joy. That regime has filed, we're going to go through this in presentation, 3, 4, 5 different lawsuits. 2 of those have been handled, or 2 or 3 of those have been handled. So there are 2 pending cases against this village, and 4 council members that sit on this, at this table as well. And so, what Councilman Joy is really after is he wants to see what's going on in those narratives, so he can pass that information on or disclose it. And imagine if this privilege is waived, that's certainly lawful. That opens that door, and it's a free-for-all. That's not the best interest of the village. But again, not my privilege, your privilege, meaning the village's. Where a member of council has taken positions adverse to the village, including prior litigation or complaints against the village or its council, disclosure of privileged communication, that individual presents additional legal risk and may be inconsistent with the village's obligation to protect its interests as the client. In this case, Councilman Joy has attempted to file 2 complaints with the Bar Association against Law Director, file a public records action in Ohio Court of Claims, Joy v. Village of New Lebanon, seeking the same unredacted invoices, which judgment was entered for the village and costs were assessed. When I say costs, those are just minor. That didn't cover the attorney's fees that was generated by unnecessary litigation. Now the proposed resolution issue, in this opinion, a pattern of conduct demonstrates an adversarial relationship between Mr. Joy and the village that weighs strongly against the voluntary disclosure of privileged communications to him. Disclosure of privileged narratives to a council member has demonstrated active opposition to the village and its legal counsel would be inconsistent with the village's obligation to protect its interests as the client. Under these circumstances, providing privileged communications to individuals actively adverse to the village or undermine the village's duty. Under these circumstances, providing privileged communications to an individual is actively adverse to the village or undermine the village's duty to act in its own best legal interest and to preserve the integrity of its attorney-client relationship. It is noted that in Joy v. Village of New Lebanon, the Court of Claims acknowledged that other remedies may exist for a council member to obtain attorney-client privilege information in the Non-Public Records Act. The proposed resolution appears to be the council member Joy's attempt to utilize such one alternative. However, a council resolution directing disclosure of privileged materials is not a legally sound exercise of that alternative. The attorney-client privilege belongs to the village as an entity, and any waiver must be weighed against the village's legal interests as a whole, not the interest of the individual council member. Moreover, unlike a targeted request through appropriate legal channels, a resolution mandating categorical disclosure of privileged narrative descriptions carries the full waiver and subject matter waiver risk described in section 4 of this opinion. The appropriate mechanism for council to obtain information, if genuinely required for governance purposes, is not categorical disclosure, but rather a controlled process that preserves privilege, most appropriately through executive session as described in section 5. Section 4, waiver of associated risks. The attorney-client privilege may be waived by the client, however, it must be considered carefully. Disclosure of privileged material, particularly on a broader categorical basis, may result in subject matter waiver, which can extend beyond the specific documents disclosed, including related communications, legal advice, and strategy on the same subject. And that's a citation to the High Rules of Evidence. Courts have cautioned against the misuse of privilege waivers as they can undermine the municipality's legal and strategic interests. Once waived, privilege cannot generally be selectively reasserted. Accordingly, required production of unredacted invoices may expose the village to additional disclosure obligations in future proceedings or litigation. The risk of waiver is particularly significant in the context of a resolution requiring categorical disclosure. Such action would likely be construed as an intentional and broad waiver by the client. Under Ohio Evidence Rule 502A, that waiver may extend beyond the disclosed invoices to other related communications on the same subject matter. As a result, disclosure could expose internal communications, legal advice, and litigation strategies. This risk is especially heightened where prior or ongoing disputes involve the same subject matter. Now, there is an alternative, what some might call an appropriate alternative. The Court of Claims enjoyed the Village of Lebanon and acknowledged that other remedies may exist for obtaining privileged information outside the Records Act. This proposed resolution is Councilman Joy's attempt, but there's another one. As discussed in section 3 above, the charter provisions cited by Mr. Joy 42047 do not authorize categorical compelled disclosure of privileged communications. They define accountability relationships, not privileged rights. The appropriate and legal recognized mechanism for counsel to obtain additional context on legal expenditures to the extent genuinely required for governance purposes is a controlled executive session pursuant to RC 121.22G3, which permits a public body to confer with legal counsel regarding pending or imminent litigation. This mechanism directly answers the Court of Claims' other remedies language and accommodates the council's legitimate oversight interest without triggering the waiver risk described in section 4. So translation, besides the resolution, executive session review would be another option.
Currently,
Such review should be limited.
Law
to
Director
legal
McNamee
counsel,
has been droning
the
on
distribution of public
for almost a
disclosure
half hour.
materials be conducted with the express understanding that attorney-client privilege is not waived. This approach allows counsel to obtain additional context while preserving the village's legal protections.
Sir, can I get you to step back? You're kind of standing in front of the citizens that are trying to watch. Thank you.
Okay, so, and as I'll go through in the slideshow, the problem with this, that assumes that everybody in that executive session is going to keep that information confidential and not disclose it. And as this council knows, in a recent executive session, there was a leak of confidential information shortly after that executive session was held that ended up on Facebook. My conclusion, the village's current practice of redacting narrative descriptions and legal invoices is consistent with Ohio law and the requirements of attorney-client privilege. The proposed resolution is not legally required to achieve fiscal oversight and presents significant risk of waiving privilege and exposing confidential information. For these reasons, it is my opinion, legal opinion, that the village should continue to protect the privileged information and carefully consider any action that would require disclosure of attorney-client communication. The proposed resolution attempts to compel disclosure of privileged communication in a manner that exceeds council's lawful oversight authority and creates substantial legal risk.